Okay. Well, thank you guys so much for joining us today. Today's presentation is going to focus on picking a trustee and whether it's advisable to pick a professional trustee and or a private fiduciary and or a family member as your trustee. So first, let me just talk about what a trustee's job is. When you create an estate plan, typically, there are two documents that give a person the power and authority to act if you were to lose your capacity. And that person is called a successor trustee in a trust, and they're called an attorney, in fact, in a separate document called a durable power of attorney for financial affairs. So when you create an estate plan, part of the benefit of having an estate plan is these documents are going to put individuals in place that you know and trust that could take over the management of your financial affairs if and when you were to lose capacity. So whenever you create an estate plan, picking who you trust to take over the management of your finances is one of the most important roles that you're going to, or one of the most important decisions that you're going to make, is that is one of the most important roles in an estate plan. I will say that whenever we put an estate plan in place, it is often common for people to review and change their successor trustee nominations over time. So if a client came in today in 2021 and put an estate plan in place, I'm always going to ask that individual who their first, second, and third choice would be to be their financial advocate if they were to lose their capacity. And it's always prudent to have a first, second, and third choice in these documents because, with all due respect, if you and your first choice are on the way to the bank and heaven forbid you're both hit by a drunk driver and you're both incapacitated in the hospital, it's always prudent to nominate a second choice. And when you nominate a second choice, because you are nominating that individual, they do have the ability to decline that nomination. So if I were in an accident with my first choice successor trustee, and if my second choice successor trustee was out of the country for work and wouldn't be returning to the US for a period of time and decided it wouldn't be convenient or practical for them to be my trustee, they can always decline that nomination, which is why it's good to have a third person nominated. So whenever you create an estate plan, it is prudent to have at least 3 individuals in place to be a successor trustee, a first, second, and third choice. I've had people put as many as 6 people in place on these documents. But I will say that the difficulty in doing this is deciding who those individuals should be. And that is really the purpose of our presentation today. So I think in deciding on who that person should be, I'm going to spend a little time first talking about a trustee's job. So when you create an estate plan, there's 2 different hats that your successor trustee can wear. One is a hat where they can come in and take over the management of your financial affairs if you're alive but lose your capacity. Or sometimes what clients will do is they'll bring a person on while they have capacity to be a co-manager of their assets. The benefit of that is if I'm a 95-year-old woman and if I'm at a stage in my life where maybe I'm slowing down, my physical health isn't as strong, or my mobility isn't as good as it was, if I asked a person to come on and to become a co-trustee with me, it will give me the ability and opportunity to start teaching them about my day-to-day financial affairs, what bills I have, what debts I have, how do I pay my bills, do I have passwords online, what are my passwords, what are my logins. So you can bring a person on to be a co-trustee with you while you have capacity. And the benefit of that is you can teach them about your finances so that if you had a day where maybe you weren't feeling so well, you could always ask them to go to the CPA and deal with your taxes on your behalf. It's more common that people will have a trustee come in place if and when they lose their capacity. And that's when the baton would pass from you to that individual to step into your shoes and take over the management of your day-to-day financial affairs. So one really important job of a successor trustee is if you were to lose your capacity, that individual, while you're incapacitated, would have the power and authority to pay the mortgage payment, to pay your medical insurance, to basically pay all of your bills. But one thing a co-trustee or a successor trustee is not, is they do not become a co-owner of your assets. And that's really important because sometimes clients will go into the bank and they'll want to put their assets into the trust, but the person at the bank will tell them that it's less paperwork and easier to name an adult child as a co-owner of the account. And the bank will say that by adding this adult child as a co-owner, should they need to take over the management of your finances, they're already in place. But what the banks don't always explain full circle in giving that advice is by adding a third party on your account as a co-owner, their liability becomes your liability. So for example, if I went to the bank and if I wanted to put my checking account into my trust, and if the person at the bank said, but Mrs. Klippel, it's easier if we just add your daughter on as a co-owner of your bank account. And I say, okay, well, my daughter is responsible and I do trust her. Let's go ahead and add her on as a co-owner. One downside of that is now that my daughter co-owns my account, her liability becomes my liability. So if she were ever to get a divorce, her former spouse can try to claim that my asset is part of her asset because California is a community property state. If she were to get into a car accident, her creditors could lien my account because it's also her account. And what happened to one of my clients is they did add an adult child as a co-owner on her account versus having her adult child come on as a co-trustee. And when the IRS audited her daughter's social security number, they automatically took over $100,000 out of my client's account because her daughter owed back taxes to the IRS. And my client had no idea that her daughter was having tax troubles. So one really important thing to understand when it comes to picking a trustee and who that individual should be is when you do bring on a person to be a co-manager of your accounts or to become a successor trustee to manage your accounts when you die or when you become incapacitated, they do not own your account. So by them not owning your account, their liability doesn't affect your assets, which gives your assets protection. So I've had a lot of people ask me, is it better to name my adult child as a trustee, or is it better to have a friend or a professional trustee or a private fiduciary? So let's talk about that, because I think that is probably everybody's number one question in attending this presentation today is how do you pick a successor trustee and what are your options in making that selection? So just going full circle one more time, one potential job of a trustee is to manage your finances if you lose your capacity, or to co-manage your assets if you want to bring somebody on in that capacity while you're alive but still have capacity. The other side of being a trustee is when you pass away, that is when your trust becomes irrevocable, and that is when a trustee's job is to administer your estate. So what is involved in trust administration is a couple of steps in California. So everything we're talking about today is California specific for those of you who have trusts that are written and interpreted under the laws of the state of California, because all states in the United States do have their own estate planning laws. So I had a client just recently who had a property in Michigan. I advised her to put that property into her California trust, but unfortunately she didn't get around to finishing that process. So when she passed away, because she has an asset in the state of Michigan, but the bulk of her assets are in the state of California, her successor trustee has to hire an attorney in the state of Michigan to help them with the administration of that particular asset, because that asset is governed under the laws of the state of Michigan. So when you name a trustee and you pass away, their primary job is to do trust administration due diligence, which involves sending all the beneficiaries a document called a notice to beneficiaries. When a person dies, one of the first things the trustee does is they send out the notices. The purpose of the notice is to advise the beneficiaries in a trust that the trust is being administered. You also have to send the beneficiaries copies of the trust, because legally when you die, your beneficiaries have the right to read your trust and to see what it says. And then you also have to send with the notice a copy of the most recent will. So one of the first things that a successor trustee does is they send the notice to beneficiaries. And the purpose of that notice is it opens and closes a statute of limitations for any of your beneficiaries to contest the estate. If you send the estate planning documents with the notice, the beneficiaries have a 90-day period to contest the estate from the day they received the notice. If you don't send the estate planning documents, and if at any time any of the beneficiaries request a copy of those documents, then the beneficiaries have 120 days to contest. So I always advise my trustees to send the legal documents with the notice, because legally there's a reason why California wants the beneficiaries to be able to read the documents. And for transparency purposes, it's always better for the trustee to share that information with the beneficiaries than to keep it private and confidential. After you send the notice to the beneficiaries, the next thing that the trustee is going to do is to determine whether or not there's a probate. When you die in California, if you own real property that's not titled in your trust, and if it's located in the state of California, having real property outside of a trust will always trigger a probate. So one of the other things a trustee has to do is they have to look at how the title to your real property is titled to make sure that the property is titled in the trust. If it's not titled in a trust, then the next thing that the trustee does is they open a probate with the San Diego Probate Court. The other thing that requires probate in California is if a person dies and if they have assets individually titled in their own name that do not have a beneficiary attached to them, then the trustee has to add the value of all of those types of assets together. And if the total aggregate value of those assets exceeds $166,250, then those assets will also trigger probate. So I had a client that had a beautiful house in Sunset Cliffs. And when we did her estate plan, I prepared a deed and I put her house into her trust. She told me during our meeting, when I advised her to put her bank accounts into the trust to make sure that that wouldn't trigger a probate, she told me that she had a bank account that had almost $190,000 in it, and she didn't want to add a beneficiary to the account, and she didn't want to change the title of the account to make it in the name of the trust. I asked her why she felt that way, and she said that she's had that account for almost 30 years, and she was afraid if she added a beneficiary or tried to change the title of the account that it would affect the account and the account number, and she didn't want any of that information to change. So she had one adult daughter that was in her 30s, and I encouraged her. I said, if you are comfortable, probably the best thing to do would be to name your trust as the pay on death beneficiary, which shouldn't affect your account number or title or anything with the account. But she said to me, I don't want to do that. So I said, if you're not willing to do that, then why don't you add your adult daughter on as a pay on death beneficiary? Because the value of that account was over the $166,250. If she had her daughter named as a pay on death beneficiary, and as long as her daughter survived her, then that account would avoid probate when she passed. But she laughed and she says, Heidi, I will spend that money before I die, and it's a problem. But unfortunately, a couple months later, this sweet lady passed away unexpectedly of a heart attack. Her daughter called, said, Heidi, I don't think my mom ever did anything with that account. So even though she had a trust, we still had a probate situation because she had an asset that wasn't titled in the name of her trust. And because the value of that account exceeded $166,250, and there was no beneficiary attached to that account, we did have to take that account through probate. So the second thing a trustee does is they determine whether or not there's a probate that has to occur. Luckily, in most situations in California, there's not a probate, because part of the whole point of doing an estate plan is to avoid probate. But when you do an estate plan, it's how your assets are titled that determines whether or not we go through probate. So making sure that your assets are titled correctly is really important. The next thing that a trustee does in administering a trust is they send a document to all of the beneficiaries called an accounting. California state law requires the trustee to send to the beneficiaries that are getting a percentage of the estate an accounting. And the purpose of the accounting is to show the beneficiaries how much monies are in the estate, what bills are in the estate. And that's basically going to give the beneficiaries a pretty good idea as to what the net value of the estate is. But when you have a trust, if you have a person who's getting a specific amount of money, let's say a $5,000 gift, they're not entitled to the accounting because they're getting $5,000. But if you're a named beneficiary getting a third of the estate, then you are entitled to an accounting, because the whole purpose of the accounting is to show you that when the trustee gives you that check for your 1/3 of the estate, you'll know how they got to that number. So after the accounting is sent to the beneficiaries, now we're in a due diligence period where the trustee's role is to pay all the debts of the decedent, to go through the decedent's home, to read the estate planning documents to see how the tangible personal property is supposed to be distributed and handled. They also have to talk to the decedent's CPA to make sure that the final state and federal income taxes are paid, current, and filed. Sometimes people don't file tax returns in their last couple of years of life, whereas other people do have tax returns that need to be dealt with and filed and paid. And then you get to a stage where after you've gone through a person's important papers to figure out what retirement assets they might have, life insurance accounts they might have, bank accounts, checking accounts, you need to make sure that any account that's in the trust is going to be part of this trust administration process, which means those assets won't be distributed by the trustee until after the trust administration process is finished. There's a different type of an asset that a trustee will encounter that's going to have what's called a pay on death beneficiary. Your retirement assets, your 403Bs, 401Ks, IRAs, name individuals as beneficiaries on those types of assets for tax reasons. So when a person passes away and once the trustee has that original certified death certificate, they will provide that death certificate to a financial institution for purposes of having the institution contact the beneficiaries that the decedent has named to inherit those assets. The financial institution will also send the beneficiary a claim form, and the beneficiaries will then fill out how they'd like to receive those monies. Because when it comes to tax deferred assets like retirement assets, the beneficiaries can take a lump sum distribution of those monies, or they can take those monies over a period of time. But a trustee's job is to simply notify the financial institution that a person has passed, because as long as there's beneficiaries attached to that asset, the financial institution will deal with the beneficiaries directly. So once we get through this stage of the process, which by this point in time, we're about 90 to 4 months into this process, the trustee is going to send to the beneficiaries another accounting that's called a final accounting. And basically the final accounting is an accounting that's going to show the beneficiaries from the beginning of the trust administration to the end of the trust administration. Here's the monies that were in the estate. Here's the bills that have been paid from the estate. Here's any income that has come into the estate. Here's any creditor bills that have been paid. Here's the taxes that have been paid. Here's attorney's fees that have been paid. And basically the purpose of the accounting is to show the beneficiaries from the day the person died to the date of proposed distribution, here's the financial history of the estate. And once the trustee sends that notice or the accounting to all the beneficiaries, they do have a period of time to ask questions about the accounting. They also have the ability to object to the accounting, which is not deemed a contest. But with the accounting, the trustee is also supposed to attach statements that verify the information in the accounting. So legally, the beneficiaries have the right to read the bank statements. They have a right to see the appraisal if there's real property, and all of that type of information needs to be attached to the accounting as exhibits. Once we get to that stage, then assuming all the beneficiaries have reached whatever age contingencies might be in place in the trust, that's when the trustee can make final distributions from the trust estate. And under California law, once all of the assets have come out of the trust and have been distributed to the beneficiaries, that's when the trust terminates by operation of law, and that is when the trustee's duty is completed. So I explained all of that to all of you to give you an overview as to what trust administration looks like, because I think it is important to understand the job of a trustee, to understand how do you pick the right trustee. So oftentimes people will ask me, should I name my adult children to be my successor trustee? And the answer to that question is truly, it just depends on your adult children. Some people have family situations where their kids all get along, their kids all trust each other, and their kids are all diligent people, where if you did name one of the kids as the first choice trustee, maybe another child is a second choice trustee, and maybe a different child is the third choice trustee. In some family situations, that works very well. I will tell you that in my estate planning practice, probably 90% of my clients do have their adult children in place as their successor. Well, I shouldn't say 90%. Probably it's more like 60% because a lot of my clients have younger children. But are a majority of my clients whose successor trustee nominations do involve their adult children. Sometimes clients will have two kids acting as co-trustees. Other times clients will have one child first, a different child second, a different child third. I've had some people say that they want to put their kids in place as by birth order. What if you don't have children? I'm coming to that, Carol. That's a great question. But just going back to my last point, I'm not a big fan of naming children by birth order because to me, that's a bit arbitrary. When it comes to picking a trustee for all the reasons that we just went through together, you really want to pick the child who's financially astute, who's good with money, and who the other kids would trust. Because with all due respect, in every family, there's usually one person who tends to be better at that than the others. And that's really the person you want to have first. It's not about birth order. It's not about hurting feelings. It's about, if heaven forbid, if you were hit by a drunk driver and if you were in the hospital, which of your adult children is going to be that person that's going to be who's going to be the best at making sure that the property tax are paid on time, that the homeowner's insurance is paid, and that the car insurance is paid. That's the person you want to pick. So going to Carol's question, that's a great question. Not everybody has children. Not everybody has children that they feel would make good trustees, and that's okay. I run into this a lot as well. So my second option, because I'm going to go through 4 options, so just know there's a couple more options coming. My second option is you can always look to your extended family and close friends to be a trustee. One of the nice things about an estate plan is there is language included in all estate plans that gives your successor trustee the ability to hire professionals to help them in their capacity as a trustee. So your trustee is going to be able to hire an estate planning attorney if they want to help hold their hands and walk them through this process. And the trust will pay that attorney's fee. The trustee can also hire a CPA, and the trust will pay the CPA's fee, because most trustees, probably with all due respect, shouldn't be preparing a final state and federal income tax return because maybe they've never done it before, whereas that's something that a CPA does every day and is very well at handling. And then we get back to the point of not everybody necessarily has family and friends that they want to ask to do this job. Other times people don't want to place that burden on their family and friends because they truly feel, I've had a lot of clients say, my sister, she'd be a great trustee, but everybody's put her as a trustee. And frankly, I think she's sick of it. I get that a lot too. So my advice is, if you have somebody like a sister who everybody else is named as a trustee, and if that person really is a good trustee, you could always put them on your estate plan, but you are just nominating them. So when and if life happens and they need to make the decision if they're willing to be your trustee, whoever you name in that first position can always accept the nomination to act, or they can decline it. And that's why it's prudent to have a second choice and a third choice, because if the first choice listed is now incapacitated, I have a lot of adult clients who will put their parents on as a trustee, but their concern is, well, gosh, my dad is 70 years of age. What if in 20 years he's no longer a good candidate to be my trustee? Well, part of doing an estate plan is making sure that you do review it every 6 to 8 years, because the laws change, the language in the documents needs to be reviewed and sometimes changed. And as I mentioned earlier, oftentimes people will change their successor trustee nomination more often than they change anything else. So now let's assume that there isn't a family member or close friend that you're comfortable putting in place. Now we're in the professional trustee arena, and you've got 2 options here. You've got corporate trustees, which are your big corporate legal department in a financial institution type of trustee. So pretty much every bank and every financial institution now has a legal department. So if you bank at Bank of America, they have professional trustees at Bank of America that you could plug into your documents. If you work with a financial advisor, they often have a corporate trustee department that could come in and act as a trustee. When you nominate a corporate trustee to act, generally speaking, their rate of pay is going to be 1% of the gross value of assets that are in the name of the trust. So when you name a corporate trustee, all corporate trustees, all individuals have a different way of being paid, but most corporations and corporate trustees are going to charge 1% of the gross value of your estate as a corporate trustee fee. Sometimes that can be problematic if you have younger children. If you have other children, let's say like my kids, they're 13 and 12. My trust says that they get all their money when each of them turn 35. So if my husband and I both died yesterday, if we had a corporate trustee in place, one downside, in my opinion, about that is if because our trust says that the kids aren't eligible to get monies until they're 35, that means if we died yesterday, that's almost 20% of their money that's going to pay a corporate trustee. Whereas if we named a loved one as a trustee, we get to decide how much money we pay that individual, whereas most corporate trustees are going to take that 1%. So if you have age contingencies that say that monies won't be released to a beneficiary for a period of years, you want to take that cost into consideration when you pick a professional trustee. When you pick the fourth option, which is a private fiduciary, private fiduciaries are individuals that are professional trustees, but the nuance between a corporate trustee and a private fiduciary is the private fiduciary is a mom and pop. It's a me, myself, and I. It's a person who is a licensed professional who's a professional trustee, but they don't have the backing of a large corporation like Bank of America. Private fiduciaries make excellent fourth options as well. And the nice thing about private fiduciaries is you can interview them, you can ask them what their fee structure is. Some private fiduciaries charge an hourly fee. Other private fiduciaries will charge a percentage. Most private fiduciaries will negotiate their fees, so that's something you can negotiate up front. One thing I like about a private fiduciary, unlike a corporate trustee as a trustee, is you know who that individual is. Whereas corporate trustees, with all due respect, and I'm not trying to be critical, but this is just something that I've observed that occurs. Corporate trustees will change their employees over time. So one downside to a corporate trustee is you don't necessarily know who that person is that would be in place acting as your trustee. So if Bank of America, I have a friend who's a corporate trustee with a bank down the street who's amazing. And unfortunately, with COVID, she was recently laid off. So she's been very instrumental in talking to her clients, and her clients know her as the face of that trust department. But now she's no longer the trustee that's in place that would handle her or her client's trust if they needed help. The bank now has a new person who's come into that role who's taken over that position. So corporate trustees don't always nominate, or I'm sorry, they don't always tell their clients when the person who's in charge of the helm of their trust department is changing. So if you do name a corporate trustee, which is fine, my advice to you is to make sure that you're on top of reaching out to that to the corporation, finding out who the current person is who's handling their trust department, interview that individual, make sure that you're comfortable with that individual. And if at any time that individual changes, make sure that you take the time to meet the new individual that's taking over that department, so you know the face of who that person would be, who would be acting as your corporate trustee. And as I mentioned earlier, when you create the trust and when you create a durable power of attorney, whoever you name can always be changed and it can always be updated. So over a period of time, if the people that you have in those roles, if relationships change or capacity changes or people's health changes, or maybe somebody's experienced a life situation like a divorce, or maybe you know that now that they have a gambling problem and you don't want them in charge of your money, changing who those individuals are tends to be the number one change people make in their estate plan. So generally speaking, when you are thinking about who these individuals will be, your options are, it can be family, whether it's your adult children, whether it's your extended family, whether it's your niece, nephew, brother, sister, mom, or dad. It can be a close friend. It doesn't have to be a blood relative who's named in these documents. It could be your neighbor if you happen to be lucky to have a really good relationship with your neighbor who you know and trust. It can be a corporate trustee, or it can be an individual or a private fiduciary. And you can always review these nominations and update them over time. So Suzanne was nice enough to send me some questions that she wanted me to talk about during the presentation today. So I'm going to go through these questions with all of you, and then I'd like to answer any questions that you guys have. The first question was, what if an aging couple chose to stay in their home? They have capacity, but they want to outsource all of their financial management, i.e. bill paying, taxes, to a fiduciary, so that one day, if and when they lose capacity, they are already set up. Have you seen this done before? So the answer to that question is it is not uncommon when people get to that stage in life where they feel that they're physically slowing down, or if they've been diagnosed with an illness that involves a diminishing capacity. That is often when I start having a conversation with my client to see if they would feel more comfortable having somebody come in place now to start co-managing their assets and act as a co-trustee, and to have the durable power of attorney give these financial powers effective immediately. If And that's something that's really up to the individual. Some people are very comfortable bringing people on while they have capacity and teaching them about this, whereas other people tend to be more private and don't really want people to have the ability to come on and start helping them until they need to. I have had some clients pick bookkeepers to come on and help take over with the management of their monies instead of a private fiduciary. The nuance is a bookkeeper is not a fiduciary, so they're not under the same requirements under the law. Whereas a private fiduciary, whenever you act as a trustee or a private fiduciary or a corporate trustee, that is a legal standard that requires the person who's acting to exercise a standard of care, to use reasonable judgment and discretion. So if they make a mistake, even an innocent one, you and or your beneficiaries could take them into a court of law, and a judge will take whatever actions they made very seriously and ask them a lot of questions. And if the judge finds that a fiduciary has violated or breached a duty, then that individual will be expected to pay damages to the beneficiaries or to the individual out of pocket. Whereas when you have a bookkeeper in place to help with the day-to-day or monthly management of assets, they aren't acting in a fiduciary capacity, but their rates tend to be lower than a private fiduciary's rates to do comparable work. So the second question was, why is a fiduciary better than having just the kids take charge? I think I honestly don't know if I would say that a fiduciary is necessarily better. One nice thing about having a private fiduciary in place is they know what they're doing. So a private fiduciary knows what it means to administer an estate, and they are experienced in dealing with a person's assets when a person is alive and incapacitated. The other benefit of a private fiduciary is they are a neutral, disinterested party. So sometimes it's better not to get the kids or family involved, and to have somebody who is an independent, neutral third party come in, because that way it keeps everything neutral. I have seen situations where a person dies and they'll have one of the family members, whether it's a brother, sister, or adult child, come in as the trustee, and not everybody trusts that individual, and that can create problems that don't have to be there. Whereas if you do have a private fiduciary or a corporate trustee in place, because they aren't related, people tend to trust the process more. But I will say, talking about the con on that is I've also seen corporate trustees who are very reluctant to exercise a lot of discretion, because legally, when a trust gives a trustee the discretion, that does open up the door for a beneficiary to sue that beneficiary if a beneficiary doesn't agree with the decision made by the trustee. So one of the things I'll ask clients in doing an estate plan is if they want to put a drug testing clause in place, so that if the trustee does reasonably believe that a beneficiary is having an issue with illegal drugs, if the beneficiary tested positive for illegal drugs, the corporate trustee would have the ability to postpone a distribution to that beneficiary. But that does involve discretion. And I've seen that oftentimes when you have corporate trustees or private fiduciaries in place, those types of clauses in a trust that involve discretion are often ignored, because the corporate trustees have been told by upper management to avoid lawsuits to not exercise discretion. If you have an estate plan where you do need discretion built in, that can also be a problem if you have somebody who's not willing to exercise discretion. So for example, my estate plan says that each of my kids will inherit monies when they turn 35. But we did authorize distributions for the kids when they turn 25, 30, and 35. But while the kids are under 35, there's language in our trust that allows the trustee to make distributions to the kids regardless of age for their health, education, maintenance, and support. So if my daughter was going to college, the trustee can use monies from her share of the trust to pay her tuition. But part of where having discretion is important is if my daughter was flunking out of college, I would want my trustee to postpone or to cut off that tuition payment until my daughter brought up her grades. And there are trustees that won't exercise that kind of discretion because they're afraid of the liability and potential lawsuit of being sued. So sometimes you have corporate trustees that don't want to upset the beneficiaries because they're afraid of the beneficiary bringing a lawsuit. So they don't exercise discretion at all. So if you have younger beneficiaries, or if you have a beneficiary who has substance abuse issues, then you might want to put an individual in place, maybe even a private fiduciary instead of a corporate trustee. So one nice thing about doing an estate plan is these are the types of questions that your attorney should be asking you, because when you pick these individuals to assume these roles, picking a trustee is oftentimes the difference between a very successful and efficient trust administration versus having maybe not the best trustee in place and having a trust administration go south. So if it always is very important to have the dialogue about what your options are and what's going to be the best choice for you, because every estate plan and every family situation is different and every individual's needs are different. If I wanted to give all of my estate, for example, to the San Diego Zoo, I'd probably just name the San Diego Zoo as my trustee, because if they're ultimately going to inherit my estate, then I would be comfortable with them administering my estate because it's a win-win. But one downside sometimes of having a corporate trustee in place is not all corporate trustees will be your trustee if you're alive but lack capacity. So for example, if I name the San Diego Zoo to be my trustee because I'm going to give all of my estate to the San Diego Zoo at my death, the San Diego Zoo would be more than happy to administer my estate, because once I die, they could take the monies for my trust and pay my final tax return, pay my final bills, and do all the due diligence. And then once they finish the trust administration process, whatever monies are left is for them because that's what they'll have inherited. But on the flip side of that coin, if I'm hit by a drunk driver and if I'm in the hospital incapacitated, with all due respect, the San Diego Zoo doesn't want to be involved in paying my property taxes or making sure that my health insurance is current and paid. So sometimes you do have a situation where having a corporate trustee makes perfect sense when you pass away. So they're what's called a death trustee. But sometimes you have to pick a different person or individual to be your incapacity trustee. And that's okay. I write plenty of estate plans where you have one list of people to come in and be the trustee if a person's alive but incapacitated. And then you have a separate list of trustees to come in place after a person dies, because that's generally after you die. That's when the corporate trustee is willing to come in because they basically know the trust administration process. Okay, so then the next question, I have two more, is what happens when a fiduciary is incapacitated or retires and is still handling an estate? That's a great question. So all estate plans have language in them that say when a person becomes incapacitated, they're no longer eligible to be your trustee. But the honest to God difficult thing in that type of a situation is sometimes people do lack capacity, but they haven't gone to the doctor and they haven't been diagnosed as lacking capacity. So in California, there is a bit of a gray area, and that makes my job really, really tricky, because sometimes you have a situation where a person really shouldn't be acting as a trustee, but they're not willing to go and get the diagnosis. And with HIPAA and doctor-patient privilege laws, it's really difficult sometimes when you have a trustee in place who really doesn't have capacity, who's insisting that they have capacity and they're in charge of your financial affairs. And in a situation like that, generally speaking, unless you can get the person to come to mediation or to voluntarily step down, you're usually going to have to go through an ex parte court process and have a judge get involved, which is really unfortunate because that delays things and it's an expense. So my best advice is for all of us is whenever you have an estate plan, you always want to be mindful of who you've listed in your estate planning documents to assume these roles. And you want to put on your calendars a reoccurring event about every 4 to 6 to 8 years to review who you've named in these roles, because it's not uncommon for you to want to update the list based on people's health, mental fitness, and capacity. So I just saw a question, which I'm going to answer, and then I'll get to this last question that Suzanne sent me. And the question was, what is capacity? And that's a fantastic question, because I can tell all of you, I am not an MD. I am not a medical doctor. So my job as an attorney is, if I get a sense that I don't think that a person has capacity, my job is to have them go to the doctor and have a test done so that a doctor who is a professional can gauge a person's capacity. So sometimes I'll have people call my office, and if, for example, I had a client just a couple of weeks ago. The son called because mom wants to change her estate plan. There's two kids, it's him and his brother, and the son's calling telling me that mom wants to change her estate plan, giving him all of her estate. Well, that makes the hair on my neck raise up a little bit. Why isn't your mom calling me? Why isn't your mom telling me that she wants to give everything to you and not to both of you? So there are things, with every profession that you learn, you look for red flags. Before COVID, when we would do in-person meetings, if a client of mine was being driven to my office by a third party and didn't drive themselves, that is a red flag to me. And that's when I'll start asking the client more questions to gauge what I think is their capacity. I'm not, as I mentioned, a medical doctor, so legally I'm not under a legal duty to make a diagnosis, but there are ways of being able to tell if a person has the capacity to do an estate plan, because in California, a person has to understand the nature and scope of a legal document to be able to create and sign a legal document. So part of what I do in situations of trying to gauge a person's capacity is I'll ask them questions about why they want an estate plan, and if they understand how an estate plan works. And then once we start having a conversation about putting their estate plan in place, trustees, updating trustees, generally you can tell when a person understands what they're talking about by how they answer those questions. So anytime I have a situation where I don't feel that a person can answer those questions, that's when I know that I could have a potential capacity issue. And whenever that happens, I always stop what I'm doing and I'll explain to my client that I'm going to need them to go to their doctor, and that I'm going to need them to um, have their capacity checked, because one of the things that I'm very cautious of is I'm not really doing a client a favor by updating their estate plan or creating an estate plan if those documents could be challenged based on a person lacking capacity. So gauging capacity is something that all of us attorneys take very seriously. I've had situations where I've had a husband and wife tell me that they don't want a certain adult child involved in their estate plan, and now mom is in a memory facility, dad has an in-home healthcare provider. Now that adult child that mom and dad both told me they never wanted to be involved in the estate plan is calling me, telling me that mom wants X, Y, and Z. So even between spouses, you can have a potential of conflict of interest where, you know, maybe people's interests start to change over time. And that can be a difficult situation. And oftentimes, what happens in a situation like that is an attorney is conflicted out and they have to step down as legal counsel. In that situation, I advised each of them to retain their own separate counsel because the son was becoming a problem. Okay, so I have one more question that Suzanne wanted me to address, and it is, can you please give some cost examples of hiring a fiduciary, a state of size X percentage of cost? So in California, if I named my father-in-law as my successor trustee, I get to decide how much, if any, I pay him. I've had many clients say that they don't want to pay their successor trustee, in which case a trust will say no compensation. And if a trust says no compensation, then the trustee can't be paid. Personally, I'm of the opinion that if you're going to ask somebody to step in and do this job for you, because it is such an important job and it does take an individual's time, I think you should always offer compensation. That's just my personal opinion. And whether a person accepts compensation is up to them. I've had a lot of people come in my office that will say initially at the beginning of a trust administration that they don't want to be paid. And then and I'll always tell them, how about we defer that decision until the end? I see that question, Roger. I'll get to it in just one second. So what I always encourage people to do when they start the job as a trustee is to wait to make the decision as to whether they want to be paid until the end of the job, because I don't think people always realize that when you administer a trust, it is a process. I mean, in addition to paying a person's bills and closing their credit cards and talking to their CPA and dealing with their taxes, there's always a possibility of talking to beneficiaries about selling the real property. There's always tangible personal property that does take time to distribute, to donate. You've got safe deposit boxes that sometimes you can access, sometimes you can't. You've got accounts that don't always have beneficiaries that under California state law will be frozen for 40 days. You've got beneficiaries that, with all due respect, sometimes are real time sucks where they want to call every day and ask for money and what are you doing and when do I get my money, because they have no idea of the process involved. That can be a tricky thing when you have beneficiaries that are constantly calling and constantly asking questions, because sometimes, as a courtesy to my clients, I'll let the beneficiaries call and direct those questions to me, because sometimes in a broken family dynamic, it's better to have a third party answering those questions because the trustee doesn't really want to be involved. And I'll have people call sometimes 5 times a day asking me the same question that I just answered literally 15 minutes ago. So administering a trust honestly should not be a difficult process, but depending on the players and the individuals, it can take on a whole life of its own. I've even had a trustee, sadly, that I've known is intoxicated as a trustee, and I'm kind of surprised that none of the beneficiaries have come on and challenged this trustee's ability to be a trustee, because I know that I always make a point to call this trustee before 9 a.m. because usually by 10 a.m. this trustee is full on intoxicated and can't keep a sentence together. So I've seen the whole gamut. I've been doing this for 20 years, which isn't a lifetime, but we've helped administer a lot of trusts and we've seen a lot of different things. And based on all of that, I will say that picking your trustee is honestly the most important part to an estate plan, and reviewing those individuals is a really important part of an estate plan. So I didn't really answer this question fully. And Roger, I'm going to come to your question. So examples of costs of hiring a fiduciary. I've seen some fiduciaries charge $75 an hour. I've seen some fiduciaries charge $500 an hour. As an estate planning attorney who had to go to college and go to law school and pass the California State Bar, I charge $395 an hour. So I've seen private fiduciaries charge more money per hour than I do, and they don't have a legal education. And oftentimes they end up hiring an estate planning attorney to help them through the process because they don't always know what they're doing. So one thing that I do want to say is when it comes to picking a private fiduciary, you always want to make sure that you take the time to interview those individuals. With all due respect, not all private fiduciaries are very good, just like not all estate planning attorneys are very good. In every profession, you've got some really outstanding, remarkable people. And then you've got, sadly, some people that, with all due respect, have no business doing what they're doing. So I've seen private fiduciaries with hardly any experience that are charging almost $500 an hour, which is mind blowing. I've seen a lady, I don't want to say too much about her. I know another fiduciary service that charges 3% as fiduciary fees, where most corporate trustees charge 1%. So why she, as an individual who doesn't have the backing of a corporation and big pockets, is charging 3 times as much as a corporation who has the backing and the deep pockets doesn't make any sense to me. So it's really important when it comes to picking a trustee. If you're picking a family member or a friend, you get to pick the compensation. If it's a corporate trustee, they've already got it decided. So ask them that question. Most corporate trustees are going to charge about 1% of the value of the estate, and they can charge that every year that the estate is open. So if I died and if I've got age contingencies and my estate's going to be open for the next 10 years, that corporate trustee gets 1% every year that they act. So off the top, that's 10% going to the corporate trustee, which in some situations is money well spent. In other situations, if a trust is going to be open for a prolonged period of time, that 1% over a long period of time can end up being a pretty significant chunk of the estate assets. Private fiduciaries, as I mentioned, I've seen the whole gamut. I've seen $75 an hour. I've seen $500 an hour. I've seen private fiduciaries who are outstanding, who have years of experience charging $75 an hour. And I have met private fiduciary at different attorney functions that have very little experience and they're charging $500 an hour. So when it comes to a private fiduciary, really take the time to ask the questions, ask about their experience, ask for referrals, talk to clients that have worked with them, make sure that you're doing it. You almost want to treat a private fiduciary like you're hiring an employee or a caregiver. You want to do the research, you want to ask those tough questions, you want to make sure you're on the same page. And the tricky thing about a private fiduciary is you have to pretty much do that 3 different times, if not more, because the document needs to have a first choice, second choice, third choice. Because I know a lot of private fiduciaries that are sole proprietors. So if you've got a private fiduciary as your first choice, but sadly, if they're in the car driving you to the doctor and you're both hit by the drunk driver, you're going to have a second person in place to take over the administration of your estate. So Roger, your question, which is a great question, was, does the person need to live in California? And the answer is no. Your trustee can live anywhere. When it comes to picking a healthcare agent in your healthcare directive, I do think it's important to have somebody in that document who's closer to home, because honestly, if I were hit by a drunk driver and if I were in the hospital, I would want a healthcare agent who would be at the hospital, who would be talking to my doctors, preferably person to person whenever possible, because that's usually how you're going to get the best advocacy. Whereas for trust administration, you don't have to live in state, but generally speaking, the trustee will want to come to the state at least once to, hire a realtor in person, sign contracts if need be. And the trust would cover the expenses of that flight and the hotel and the meals. I have had trustees that are out of state that have never come in state to administer a trust, because with Federal Express and computers and DocuSign, you can do a lot of that stuff from different states. So legally, there's not a requirement that a trustee be in the same state and or county. Is it more efficient to have somebody in state? Honestly, I know it sounds silly, but it just really depends on who that individual is, because I've seen some pretty effective people handle estates from outside of the state. And I've seen other people that are just a couple of doors down from their loved ones who are pretty ineffective. So picking a trustee really comes down to personality and a person's diligence. You want to pick somebody who's diligent. You want to pick somebody who's transparent. You want to pick somebody who is a good communicator. You want to pick somebody who's good with money, because if you were to lose your capacity, that is one of the number one and important things you're entrusting them with, is the care and management of your money when you're at the most vulnerable and lack the capacity to have the oversight to check on what they're doing. So I can honestly tell you, I've seen individuals administer trust and they've done an amazing job. And I've seen individuals administer trust that have done a really bad job. I've seen really amazing corporate trustees, and I've seen pretty lousy corporate trustees, and I've seen pretty amazing private fiduciaries, and I've seen pretty ineffective private fiduciaries. So you really have to just, and I know this sounds silly, but it's one of those common sense things of when you meet with somebody to talk to them about the trust, whether you're interviewing them or whether it's a family member or close friend. I think during the first couple of minutes of that conversation, you're going to get a sense as to whether this person is trustworthy and would be a good choice. And I would make sure, I know it sounds kind of naive, but I'd go with your gut, because I think your instinct in the first couple of minutes of having this conversation is usually going to be right on. I just saw a question posted. The trust always has language that a trustee, if they're out of pocket, will always be reimbursed. So a trustee is never expected to pay out of pocket to fly to the state where the trust is being administered. The trustee is never expected to pay out of pocket to pay the attorney's fees, a CPA fee, a tax return. The other thing I want to mention is, let's say that a person died and they didn't have a lot of money and their debts exceeded their assets. In California, a trustee is never personally liable for the debts of the decedent, where in other states they are. So luckily in California, if somebody I love passed away and if their debts exceeded their assets, I'm not personally liable as their trustee or durable power of attorney to pay out of my pocket for the difference. So that is a lot of really good information about trustees and durable powers of attorney. Do you guys have any other questions? You can unmute yourself. I have a question about a trustee hiring a fiduciary. That's a great question. So one thing to know is that when you do an estate plan, the healthcare directive is the document that names people that can make medical decisions for somebody. So if you're named in the medical directive, then you would have the power and authority to make decisions about medical treatment. And if you're named in the trust and the durable power of attorney, those are your financial documents in an estate plan. So sometimes when people create an estate plan, there's a possibility that they might put you in the financial role, but maybe you're not also in the medical role. So if you are named in the healthcare directive, and when the time comes that that document gives you powers, because most healthcare directives will say that a person makes all of their own medical decisions unless and until their doctor doesn't think they can make them anymore. At that point in time, the first person on the healthcare directive would have the ability to accept or to decline the nomination to act. So if you are the medical advocate, that would give you the ability to talk to that individual's doctors. Being the medical advocate also gives you the ability to decide on a living situation for a loved one. So if you felt like a person was going to be more safe in an assisted living versus being at home, or bringing in a 24-hour in-home healthcare caregiver, then you make those decisions in your capacity as a medical directive decision maker. Whereas the trustee is going to give you the ability to make all the financial decisions. So if you wanted to hire a private fiduciary to help you make the day-to-day financial decisions, you can do that. And then the trust would pay the expense of that private fiduciary. Or instead of a private fiduciary, if you wanted to hire a bookkeeper to help with the monthly payment of debts and bills, and if you want them to have the ability to show you on a monthly basis and accounting to show what they've done on behalf of that person, then the trust would pay that person's expense as well. So sometimes people will bring on a bookkeeper to help them with the day-to-day financial management of an individual's finances, but all of that is going to be in your discretion. Did I answer your question?
Yes, thank you.
Okay. And then another question that was posted was, can you have two people as co-trustees? And the answer is yes. When you have two individuals named, generally what I like to do is give them what's called powers of delegation, which means they can make decisions together and individually. So for example, if one of them wants to go to the bank and the other one's going to talk to the CPA, they don't both have to be present and signing on everything dealing with the trust. They can delegate amongst themselves. I will say that I've seen co-trustees work very efficiently where it takes the burden off of one to have somebody to help. But I've also seen situations where you've got co-trustees and one person's doing all the work and they get resentful of the fact that they have to run everything by this other co-trustee who really isn't doing anything. So my personal opinion is I like having individuals as trustees. I feel like if you have a situation where you can put one person in place, they can pretty much bring on whoever they need to assist them. But having two people in place, depending on the people, they should really know each other. They should have a relationship already established, because sometimes putting two people as co-trustees that don't have that relationship isn't necessarily efficient either, because the communication isn't always as good. So I personally am not a big proponent of co-trustees, but a lot of people are. Okay, hold on. Donna just posted a question. It says, please say again about if California resident has debts greater than assets, the trustee is not liable. Also, anything special with reverse mortgages. Okay, so when a person dies, if I died yesterday, and if I had $200,000 of assets, but $400,000 worth of debts, my trustee is not personally responsible to pay the excess. So when people die insolvent, and their debts exceed their assets, the trustee is not personally responsible for paying that. The other question was mortgages. Somebody, can you guys all check your mute button? I think somebody's still not muted who's maybe should be muted if you guys don't mind. Were you going to ask something?
Oh, I just muted them, so you're good.
Okay, thanks. So just real quickly about the reverse mortgages. Reverse mortgages are a great idea for people that want to take the equity out of their house. The downside of that is, generally speaking, the way reverse mortgages work is because the interest compounds with the principal, which means the debt grows at a more accelerated rate. It's not uncommon by the time the person dies that there's not very much, if any, equity in the house. So when I've seen houses with reverse mortgages on them, oftentimes the beneficiaries will sell the asset because there's really not enough equity for anybody to keep the asset. But it really just depends on the family. Most reverse mortgage companies, when a person dies, you legally have to notify them within 30 days that a person's died, because that starts a clock. Legally, I mean, all reverse mortgages are their own individual contract, but generally speaking, a lot of reverse mortgages will give you a 6-month period to sell the property. And if you don't sell the property, the reverse mortgage company will come in and they'll do a foreclosure. You want to avoid the foreclosure because all they're trying to do is get their money out of the asset. They're not trying to get the beneficiaries the most money out of the asset. But most reverse mortgage companies will give you 2 grace periods of 6 months. So generally speaking, when a person dies, and there's a reverse mortgage, the family will have about a year's time to deal with the sale of that asset. It's always better for you to be in charge of selling the asset because you're always going to get the highest value. Whereas again, if the reverse mortgage company is in charge of the sale, they're usually just trying to get their money back out. So they're not necessarily trying to take the highest value of the house. They're just trying to get their money back. But reverse mortgages are fine. They don't always make sense for everybody. If you want to give your kids a house and if your goal is for the kids to be able to come and live in the house, generally speaking, as I mentioned, a reverse mortgage, the way they're structured, there's not going to be as much equity in that. Whereas if you leave the equity intact, generally speaking, it's easier for the house to stay in an estate. Whereas most houses that had the reverse mortgages, most trustees and beneficiaries agree to sell and liquidate that asset. Okay, so can you believe we've been talking for over an hour? It's hard to believe. So are you all experts now? Trustee experts? Estate planning experts? Who would have thought estate planning could be so interesting, right? Well, do you guys have any other questions before we conclude? So I know that legally you can name an estate planning attorney to be your trustee, and a lot of people like that idea because estate planning attorneys write the trust, they know how to administer trust, so they seem like a natural choice. I personally never go on my client's documents as a trustee because I don't feel I am the best choice because I am stuck in this office pretty much 5 days a week helping with other matters. Part of being a trustee means that you're going to the bank and dealing with the bank accounts, and you're going to the house and you're talking to the realtor. So if I'm going to be brutally honest, most law firms that allow an attorney to be named as a trustee, the way that actually works is you're going to have a legal secretary or paralegal doing all of the work, but the attorney is going to get paid the higher fee. So I think if you have a good relationship with an estate planning attorney, and if you're comfortable having that attorney as your trustee, you can. I know we get asked a lot if we'll be that for our clients, and I always respectfully say no. Because it's always better, in my opinion, for you to hire somebody to be a trustee that I can advise and I can hold their hand through the process, because ultimately they'll be the ones meeting the realtor at the house. I'll be here in my office doing the estate planning and trust administration. But I know a lot of estate planning attorneys that offer really good trust administration services. So I'm not trying to say that it's a bad idea all around, but I do know some law firms that do say that the attorney will be the trust administrator. They often will delegate that role to other individuals on the staff. So you're not necessarily always getting that person being at the helm of the ship, making the decisions and doing the legwork. No? All right, you guys. Well, thank you for your time. Happy Wednesday. I hope you're all having a good start to your 2021. And I thank all of you. I know that this is a difficult topic. Hopefully everybody walked away with some new information. Have a great rest of your week.
Thank you so much. Wonderful presentation. Goodbye, everyone.
Bye, everybody.